Okay, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court today. Today, I will be letting you know whether I found probable cause on your case, and then we will talk about release conditions. Today's not your trial date, so today is not the day that you want to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at another time. I've read all the probable cause affidavits, and and I've made a determination. However, you do have attorneys that represent you, and so arguments may be made, limited arguments may be made on the record today. In the courtroom, I do have an attorney from the Public Defender's Office, and there's an attorney also from the Public Defender's Office over at the main jail. I have the State Attorney's Office represented in the courtroom, as well as confinement status and pretrial supervision in case any of you are released to pretrial supervision. We also have the clerk of court that keeps the records. A limited number of you may be able to resolve your case today if it's a misdemeanor case, not felony cases, only a misdemeanor cases, and if there are no other issues and the state is able to make an offer, you may be able to resolve a misdemeanor case in the courtroom today. So with that said, we're going to start, and
Judge, if we could call a case out of turn. Good morning. How are you today?
Good morning.
The gentleman I think they've already brought up, they called me asking if we could call him first out of turn. Page 9, Samudio, on the top of page 9. Say again? Oh, I'm Adam Goldberg. I'm not Brian Reedy.
What was the name?
This is Mr. Samudio on page 9.
No, that's not.
Judge, this is Mr. Salmudio on page 9 of your docket. He's representing himself.
All right, good morning, Mr. Jonathan Samudio. You are before the court today for,
Morning, Ms. Powell.
good morning, for possession of drug paraphernalia and trespassing. Those are the two charges that are before the court today.
Yes, ma'am.
I find probable cause, and I will hear in regards to setting your bond. If the state has anything that they wish to say.
Yes, Your Honor. Good morning. Assistant State Attorney Jashama Augustin for the record. The state is requesting a $100 bond on count 1 and also a $1,000 bond on count 2.
All right, finding probable cause on count 1, the bond is $100, and on count 2, it'll be $500. Sir, no return to that location.
Yeah. Can I try to resolve it today, ma'am?
No. All right, sir, good luck. Donna Ramsey.
Hold on, Your Honor.
All right, Ms. Ramsey, you are before the court today for it's panhandling. 1 count. I do find probable cause. What does Ms. Ramsey wish to do?
Judge, can I have a moment? Go ahead, Ms. Ramsey.
I had never done that before. We had missed lunch. I did not realize you couldn't do it. I will never do it again. The police officers did tell me where I could go eat from now on. So I'm really sorry that happened.
Judge, I think she just wants to take care of this morning.
I just want to take care of it.
All right.
Your Honor, the state is offering a withhold in court costs.
All right, Ms. Ramsey, do you understand that?
No.
Okay, so to resolve your case, the state is offering today withhold adjudication, which means no conviction on your record.
Okay.
And then you have to pay the court costs that's attached to this case, which is $293. Okay, so there will be a cost that you have to pay.
Okay.
All right. So do you wish to resolve your case knowing that that will be your sentence?
Yes.
All right. To the best of your ability, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right. You can put your hand down. Ma'am, you understand everything that's going on here today in court?
Yes.
And do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
Absolutely not.
And you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for mental or emotional illness?
Panic attacks about 12 years ago.
Are you
Are
you taking any medications or anything?
No, not anymore.
Let me finish. Are you taking
I'm
any
sorry.
medications or anything that will prevent you from making an intelligent decision this morning about your case?
No.
All right. Do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
All right. What plea do you wish to enter? It's either guilty or no contest.
No contest is what you want.
No contest.
All right. I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence is withhold adjudication and court costs. Good luck, ma'am.
All right, thank you.
All right.
Thank you, Judge.
You're welcome. All right. Is there anyone else at the jail is asking to call out of turn?
Not to my knowledge, Your Honor.
Okay.
Not at Maine, Judge.
No, I'm talking about the jail. Okay. All right. On the sign-in sheet, I have on page 4, Yutzi Lagari Yutzi.
Mr. UC Legary is here present at Maine, Judge. Approach and come on up, sir.
Who just stepped out? All right. We'll recall that when she comes back in.
No problem.
All right. On page 14, I am not going to try and pronounce that first name. The last name, Lozenik.
He's here present,
Seltzer on
Judge.
behalf of Yitzhak Loznik.
Good morning, Mr. Seltzer.
His parents are
Your
present.
attorney is here present.
Good morning.
Yes.
All right, good morning, sir. How do you say your first name?
Yitzhak.
Yitzchak. Okay. So you are before the court today. Count 1 is battery on an officer, firefighter, EMT. Count 2 is possession of codeine. Count 3 is possession of THC. Count 4 is possession of heroin. Count 5 is resisting without violence. Count 6, resisting with violence. And count 7 is a municipal ordinance violation. Mr. Seltzer, have you had an opportunity to speak with the state? Is there?
Judge, I have. We've agreed on a $5,000 bond. I think the state can break it down. They broke it out.
Okay. I do find probable cause, and what was the agreement?
It would be $1,500 on 1.
Okay,
The $1,000 bonds would be kept in place on 2, 3, and 4.
okay,
$500 on 6. And an ROR in count 5. And I would, Your Honor, it's up to you, but it would include an ROR in count 7, but that's a municipal.
all right. Then I find probable cause, and I will impose the bonds as agreed upon.
Thank you,
Okay,
Judge.
thank you. ROR on 5 and 7.
Thank you, Judge.
Okay, good luck. Good luck, sir. Shebra Stevens.
She's approaching, Judge. This is Munis Ordinance.
So this is out of the city of Fort Lauderdale?
This is a City of Fort Lauderdale case?
Correct. And she's in time served, Judge.
What kind of record does Ms. Stevens have? Is she a candidate for community court?
She might be, Judge. I haven't had the opportunity to speak to her as of yet.
This is not a case of violence. It's trespassing.
Correct.
So, Ms. Stevens, we have now in Fort Lauderdale a community court where if there are services that you need, you can go to that court. They can help you to find different services that you may need. Are you interested in going to community court?
I heard about it, but I'm not really familiar with it.
It's like a diversion program, and then you have to go through and follow all their rules. And like I said, at the same time, they help you find different resources that you may need. And then at the completion of the time that they give you, the charge is dismissed. So are you interested in going to community court?
To be honest with you, not at this time. I would love to resolve this, though.
Okay, all right. All right. If you wish to resolve the case today, it will be adjudication and time served. Is that what you wish to do?
Yes, Your Honor.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down. And Ms. Stevens, you understand everything that's going on here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with your attorney?
No, thank you.
Have you ever been treated for a mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence is adjudication, time served. Good luck.
Thank you.
All right. Aaliyah Decius.
Judge, she's at
Judge, I've been advised she bonded.
Okay.
Nope, she's in Paul Ryan. And she, oh,
Okay. All right, Ms. Decius, you are before the court today for a misdemeanor capious matter on a petty theft charge. I do find probable cause, and I've been advised that your bond has been posted. Good luck.
Judge, the only thing, just while Ms. Decius is here, she told me that they were going to post bond, but she also advised me she does wish to resolve this case today. So I just want to see if that's possible, if Ms. Decius still wants to do that. She was going to ask the court to resolve this case today.
She posted her bond, and since I don't know the details of the case, she may want to consult with her attorney now that she has time to do so before resolving the case. All right. So
Ms. Decius, you're gonna get released today, and you'll have to come back and resolve a different day. Okay?
Okay.
Thank you. Thank you, Judge.
all right. Laura Thorne.
No problem, Your Honor. Good morning.
Good morning. All right, Ms. Thorne, you are before the court. There are 2 felony capious matters, counts 1 and 2. Count 3 is a misdemeanor capious. Counts 1 and 2 are no bond holds and are not for magistrate. Count 3, there is a bond of $500 that's attached. You will be going to your felony division judge tomorrow at 8:30. All right? Good luck.
Thank you.
Maureen Riley,
Medical reset, Your Honor.
thank you. All right, Sherry-Ann Cavallaro,
Medical reset.
okay.
Hancock.
Alexandria Isaacs. Okay. Frankie Hancock.
Yes, good morning, Your Honor.
All right, good morning. Ms. Hancock, you are before the court today. Count 1 is a misdemeanor capias. Count 2 is a felony, a violation of pretrial. Count 3 is a felony capias. Count 4 is a misdemeanor capias. Count 5, driving while license suspended, habitual. Count 6 is a misdemeanor capias. Counts 2 and 3 are no bond holds, not for magistrate, and you will be before your division judge tomorrow at 8:30. I do find probable cause, and I will leave the standard bonds in place on the other counts.
Thank you, ma'am.
All right,
So,
good. Yes.
So tomorrow they'll be able to give me a bond on the 2 no bond holds?
Well, you'll be able to address that with your judge, and they'll see. Okay?
And that'll be tomorrow morning?
Yes. That's what my notes say. Yeah.
Thank you so much.
You're welcome. Ivy Garcia. All right, Ms. Garcia, you are before the court on count 1, battery on an officer, count 2, assault on an officer. I do find probable cause.
Judge, I don't have a probable cause objection. I would first off ask the court to sign a photo order for Ms. Garcia.
Okay.
As to the bond, we have to set a bond on count 1. Of course, we can modify on count 2 as well. Ms. Garcia advised me she's lived in South Florida for almost a year. She lives in an extended stay motel on off of McNabb. She's been there for the last couple of weeks with her boyfriend. She's worked at Pet Supermarket for the last 7 months, Judge. She's got some grandparents in St. Pete that are going to help her post her bond. So we would just ask for the lowest possible bond on count 1 so her grandparents can post it for her.
Okay.
Your Honor, the state is requesting a $1,000 bond on count 1 and a $500 bond on count 2.
Does Ms. Garcia have priors?
No, Your Honor, she does not.
All right, so as to count 1, I'll impose a bond of $500. And then on count 2, there's a bond of $100.
Thank you, Judge.
All right.
Thank you.
Okay.
Thank you.
You're welcome. Ayub Al-Kafaji.
Ayub Al-Kafaji is here, present, Judge Main approaching. Come on up, sir.
All right, sir, you are before the court this morning for charge number 1 is robbery by sudden snatching without a firearm, and count 2 is battery causing bodily harm, domestic violence. All right, I do find probable cause, and I'll hear as to bond.
Judge, I did have a PC objection just to count 2. I don't have an objection to count 1. The allegations are that Mr. Al-Kafaji took a cell phone from... I'm sorry, that was the previous... Nope. A cell phone from his girlfriend and pushed her to the ground. I believe that act, as alleged, would constitute the robbery. You know what? I'm sorry. I misread the charge. I'm going to withdraw my objection. I apologize, Judge.
Okay, no problem. All right. As to the bond, do you want to make an argument?
I'll wait till this recommendation, Judge.
Your Honor, I'd be seeking a $5,000 bond on 1, $2,500 bond on count 2, in order no victim contact.
Does Mr. Kafaji have priors?
I'm not showing anything one way or the other. Does pretrial have any notes?
Okay. Mr. Romero?
Judge, in speaking with Mr. Al-Kafaji, I'm going to be requesting a $1,000 bond on count 1 and a $1,000 bond on count 2. I believe that's reasonable under the circumstances. First, Judge, as you heard, Mr. Al-Kafaji has no prior criminal record. He's 18 years old, and this is the first time he's been arrested in his life. He is a registered voter here in Broward County. At this time, he is currently looking for work. He's a graduate of Taravella High School, class of 2017. He was working at a hookah lounge. He lost his job. He was only making about $9 an hour. Now he's looking for other employment to try and save up. His plan is eventually to go to college, and that's why he's saving, Judge. He lives with his uncle and Davy, and that's the family friend or contact that's going to help post his monetary bond. Judge, now I know the allegation is that he ran off with the phone, and I told Mr. Al-Kafaji that unfortunately today is not his trial date. What he will do is I told him he signed up with the public defenders. He's going to actually give the written contract because the T-Mobile phone is actually his. It's under his parents' name. He lets her use it, but the phone, he's the one that actually bought it. The phone is under his parents' name. So once I believe he goes ahead and gives the actual contract to the case file, that case is going away. Judge, I understand we've been here many times in magistrate court, and you've seen many types of misdemeanors, batteries. This is a push. I don't mean to undermine it, but I believe Your Honor has seen more egregious misdemeanor batteries. So considering the circumstances that this is the first time he's had contact with the criminal justice system, his strong ties to the community, Judge, I believe a $2,000 bond is reasonable under the circumstances.
All right, I find probable cause. I'm going to impose a no victim contact order, $2,500 on count 1 and $1,000 on count 2. Roy Greer,
Medical reset.
still a medical reset. Jose Soltrin. All right, Mr. Soltrin, you're before the court. It's on a misdemeanor capias. It looks like you did not show for calendar call on February 21, 2019 on a battery charge. That court imposed a bond of $2,000, and you will be going before your division judge tomorrow.
There's nothing to add from the defense. I know he's a county sentence on a separate case. He's going to have to talk to his division judge tomorrow regarding this misdemeanor on battery.
All right, sir, good luck. Dwayne Steinmetz.
Broward, Your Honor.
Thank you.
North Broward, I believe, Judge.
All right, Mr. Steinmetz, sir. Deputy, if you can push him back just a little bit so I can actually see his face. Thank you. Well, okay. All right, Mr. Steinmetz, can you hear me, sir?
Yes, ma'am.
All right. You are before the court, sir. There are 5 misdemeanor capias matters. Some of them are municipal ordinance violations and other state charges.
Judge, I spoke with Mr. Steinmetz as it pertains to counts 3 and 4. And in the conversation, he advised he wants to resolve not only those, but everything before the court. They all look like 2014 trespass, open container, everything without.
Yes, these capias are all from 2014, sir. So, and you're Mr. Shade, you represent them on the city matters?
Correct.
All right, so Mr. Steinmetz, can you hear me? Okay, so your attorneys tell me that you wish to resolve your case today. Is that correct?
Yes, ma'am.
All right. So if you want to resolve the cases, State, did you wish to be heard?
The offer would be a withholding court cost on 3 and 4.
Okay.
Judge, they're actually City of Hollywood cases, not Dania Beach, and they would offer time served, who he doesn't really have a history with the City of Hollywood.
3, 4. All right, if, Mr. Steinmetz, if you wish to resolve these matters, the sentence will be a withhold adjudication, court costs on all of the counts.
I don't understand, Your Honor.
All right, So if I impose a withhold adjudication, it means that there'll be no conviction on your record, but there will be court costs that you will have to pay.
I have no money.
Oh, well, I can't waive the court costs. I have to impose it, so I can give you 6 months to pay, and then if after 6 months you're not done paying, then you need to go talk to the clerk's office to see if you can get.
I can do that, Your Honor.
Okay? All right, so, please raise your right hand as best as you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And Mr. Steinmetz, do you need any more time to speak with your attorneys?
I haven't spoke with him yet.
They're right here, and you spoke to one on the phone this
spoke earlier,
morning.
Mr. Steinmetz.
Well, I thought you met in person because, Your Honor, I don't want to get upset, and I respect your position, but they got me in a rubber suit and a flipping nut house over a trespassing charge.
All right, I
I
understand.
don't understand. I just don't understand.
I understand, but don't get upset, because then, I won't be able to take your plea if you're not thinking straight.
I'm thinking straight.
All right, so, do you need any more time to speak with your attorneys? There are two of them that are over here in the courtroom with me. They can talk to you on the phone if you need more time to speak with them.
Yeah, I'd like to speak with him.
Okay, did you speak to you spoke to Mr. Goldberg
Judge,
this
we
morning?
spoke earlier this morning. I'd be happy to talk to him again. That's no problem.
Do you remember speaking with Mr. Goldberg?
Yes, but he didn't really say anything.
I don't know how you have a conversation and not say anything, but
Well,
all
he
right.
just want-
All right, no, don't worry. Mr. Goldberg will be happy to speak to you,
problem.
and as soon as Mr. Shade can also
Happy to
speak
talk
to
him
you,
as well, Judge.
and as soon as they're both done talking to you, I'll recall your case. How about that?
No, let's just solve it right now. We don't need that. I'm sorry, Your Honor, but they're not helping.
All right.
They can go and
No,
get in their
no.
BMW and go and drive around.
All right.
Judge, I just want to say, I spoke with him earlier. I honestly have no concerns about his competence. so
I have no concern about his competence either. He just, all right. So you understand that you have a right to go to trial, and that by taking a plea today, you're giving up that right.
Yes, ma'am.
All right.
I just want to get it over with.
I understand. So one more question. Do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Your Honor, I was born at Hollywood Memorial Hospital.
All right.
I'm a U.S. citizen.
I just need to, the law requires that I inform you of this.
I understand.
Okay? So,
Yes, ma'am.
what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence on all counts is withhold adjudication and court costs, and I will give you 6 months to pay the court costs.
Thank you, Your Honor.
All right, good luck.
There you go. You have it here. Take the brief off.
All right, Herbie Crussell?
He's in the main jail. He's
Judge, I've been advised he's a medical reset.
All right.
standard for Herbie.
And how about David Martin?
Mr. Martin, come on up, sir. There's your attorney, Mr. Shate.
This is the City of Hollywood, 3 open container matters. The City of Hollywood offered time served with an admonishment from the court, and the City of Hollywood says, Dave, you have to stop drinking at the same location over and over. All right?
All 3 are from the same city?
It's all from the same city, Judge Court. They're all the 2018 cases, the cable system,
All right.
South Satellite.
They're all open container.
Correct.
All right. Mr. Martin,
Yes, ma'am.
do you wish to resolve your case today?
Yes, I do.
All right. Do you understand that you cannot have an open container beverage out in the public?
Yes, ma'am.
All right. So today, you are before me on those charges, and in case no one has ever told you before, it's against the law. Do you understand that?
Yes, ma'am.
So that you and I don't meet in this place again, you are going to have to make adjustments, right?
Yes, ma'am.
All right. So, the suggestion is you buy your drink and you take it home, and then you go home and sit in front of the TV and have your drink, not out in the public. You understand that?
Yes, ma'am.
All right. So if you wish to resolve your case today, your sentence on all 3 counts are going to be a withhold adjudication and court costs, but I don't want to see you here again.
Okay.
All right. Do you wish to resolve your case with the sentence?
Yes, I do.
All right. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right. You can put your hand down. Do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, I'm not.
And you understand that you have a right to go to trial, but by taking a plea today, you're giving up that right.
Yes.
Have you ever been treated for a mental or emotional illness?
No, I haven't.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Understand.
What plea do you wish to enter, Mr. Martin?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is withhold adjudication and court costs. Good luck, sir.
Thank you, ma'am.
All right, on page 8, Gary Altman.
Mr. Altman, come on up, sir. There's your attorney, Mr. Sheet. Middle, bottom middle.
All right, Mr. Altman, you are before the court for 2 municipal ordinance violation, walking through traffic and not having a required OSHA vest, and I do find probable cause.
For Mr. Altman, he has quite a bit of a history now with Pompano Beach, and what I've been told is that it's up to your honor as to whether it be time served or sent to the division, so we could have a couple more days to understand that he cannot continue to do this in the city of Pompano Beach. He has probably about 15 to 20 cases in the last.
Yes, I've seen Mr. Altman a few times before. So Mr. Altman, what do you wish to do today, sir?
Resolve it.
All right. Apparently, the city of Pompano is not going to continue to extend the time served offer to you because of the number of times that you've come before the court on these trespassing charges. So we can resolve the case today, but I need you to understand that you need to find some kind of support or help somewhere where you can go, so they don't keep picking you up on these charges. Do you understand that?
Yes, ma'am.
All right. So today I'll sentence you to adjudication and time served, but just know that that kind of sentence is going to run out in a minute. Do you understand that? All right. So please raise your right hand as best as you can. Do you swear or affirm to tell the truth?
I do.
All right. And you understand everything that's going on here today?
Yes.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for a mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Altman?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. And your sentence is adjudication and time served. Good luck, sir. Victor McCarthy.
Mr. McCarthy, come on up, please.
All right, Mr. McCarthy, you're before the court for counts 1 and 2 are municipal ordinance violations. I do find probable cause. What does Mr. McCarthy wish to do?
So there'd be a time-served offer for Mr. McCarthy.
Mr. McCarthy, what do you wish to do today, sir?
Resolve this today.
All right, sir. What plea do you wish to enter?
No contest.
All right, I accept your no contest plea and your sentence's adjudication and time served. Good luck, sir.
Thank you.
Carmen Smith.
North Road, Donna.
Mr. Smith also has a state case for possession of
Yes.
synthetic marijuana.
All right, Mr. Smith, you are before the court today for possession of cannabis, 20 grams or less. Count 2 is a misdemeanor capious matter on a disorderly
He said 10 grams or less, but it wasn't even nothing but a little
It doesn't matter. I know that Mr. Smith wants to resolve as to, I think, both counts, but he told me as to count 1.
All right. So, as I was saying, you have misdemeanor capious on charge number 2 for disorderly conduct.
I did time for that already too, but I still want to resolve it. I apologize, my lawyer.
You don't need to apologize. We
I
spoke
did
earlier.
time for that already also.
We're
Mr.
good.
Goldberg, were you able to check on this case?
It's still pending, Judge. I know he wants to resolve it. He had been in jail for it before, but he was ROR'd. It wasn't resolved, so
Okay.
we're good.
Yeah, he said ROR. Okay.
We're good.
All right. So, Mr. Smith, what do you wish to do today with these 2 cases?
I wish to resolve it.
All right. State, do you have an offer for Mr. Smith?
Yes, Your Honor. The state is offering a withhold of adjudication and court cost.
All right. All right, Mr. Smith, is that acceptable to you?
Yeah.
Withhold adjudication and court costs.
Can you explain that to me?
I'm going to let one of your attorneys do that.
Mr. Smith, you're just going to receive a withholding of adjudication. It's not a conviction on your record, and you're going to receive court costs on both matters. All right, you'll be able to get out this afternoon.
Okay, that's all right.
All right. So please raise your right hand as best as you can, Mr. Smith. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Do you need any more time to speak with your attorneys?
No, he explained to me.
All right. Are you under the influence of drugs or alcohol?
No, I'm not.
You understand you have a right to go to trial, but by taking a plea today, you're giving up that right?
Yes, I do.
And is anyone forcing you to resolve your case?
No.
Have you ever been treated for mental or emotional illness?
I don't remember. No, not that I think. No, I haven't. No.
Okay. And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I was born in Savannah, Georgia.
All right. What plea do you wish to enter, Mr. Smith? Guilty or no contest? Oh, I'll accept your no contest plea. Find that it's freely and voluntarily given, and your sentence on both counts is withhold adjudication and court costs. Good luck, sir.
Thank you very much. Thank you, my lawyer. Thanks.
Good luck.
Victor Gomez Prats. All right, Mr. Prats, you have 2 misdemeanor capious matters before the court today. Open container. Both of them are open container charges.
Correct, Judge. So the 2 cases matters from 2018. They'd offer time served on both matters.
All right. Mr. Prats, you wish to resolve your case today?
Yes, ma'am.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. Your sentence is a withhold adjudication and court costs. Good luck, sir.
Thank you, ma'am.
Matthew Kaiser. Kaiser. He's on page 23. Page 23. Sorry.
Oh, Judge, we're not even there yet.
Well, it's Mr. Shades is his attorney, but is he not in?
Mr. Kaiser on page 23, can you get him? The deputies are going again, Judge.
And then,
If we can make it easier, Judge, he's got 2 felony matters that we would just ask that to be sent to the division.
we can do that, but also on page 23, we have Charles Butler.
Mr. Butler is also.
And then is Mr. Mingo, Darwin Mingo, is he in today?
Who?
I'd like to wait around if I could, Judge. Maybe
You want to
just
wait?
an hour for Mr. Mingo.
You want to wait around again for Mr. Mingo?
No. He's
No?
still medical reset, Your Honor.
He's still a medical reset? Okay.
Yes, ma'am.
All right.
And Judge, on Mr. Butler, he's got a delivery of cocaine also. We just asked that that be sent to the division.
Mr. Butler,
Mr. Butler has delivery of cocaine?
Yes, ma'am.
but I'm gonna need time to speak to Mr. Butler. He's
well-
here. Hold on one moment.
All right, so on Mr. Kaiser, I do find probable cause, and he's going before his division judge tomorrow, right? And so we don't need to bring Mr. Kaiser. And then Charles Butler is here, and he has,
I can't tell if there's two cases, Judge, for Mr.
there's a municipal ordinance violation, and then there is a charge for distribution or delivery of cocaine. That's a new arrest. So I do find probable cause. And are we ready to address Mr. Butler, or?
Judge, I think that's a straight state case without, I think count one is just a separate, I mean, I think there's.
Yeah, I think they're two
Yes.
incidents.
So,
Okay,
thank you very much.
all right, you're welcome.
Judge, thank you. I've had an opportunity to speak to Mr. Butler. I'm ready to proceed.
All right, so I find probable cause, it's on counts 1 and 2, and I'll hear in regards to bond.
Judge, from Mr. Butler, with our conversation, there's no way he's going to be able to afford any sort of monetary bond. His first question is on count 2 of when was the alleged date of incident on that?
That's November 2018. November 15.
Judge, and speaking of Mr. Butler, he's 60 years old. He's been here his whole entire life. Right now, unfortunately, he advised me he's homeless. He's not working. He's looking for employment. From what he advised me, there's no one that can post his monetary bond, and he's not in a position to post his monetary bond. He did advise me as priors, but he's been over 10 years clean, from what he advised me. Judge, considering this is a nonviolent offense, considering Mr. Butler's basically financially indigent, at this time I'm going to be requesting the court consider releasing him on pretrial release.
All right, State.
Your Honor, the state is objecting to the pretrial release. The state is requesting that a $2,500 bond be placed for Mr. Butler. He did have a prior cocaine case in Broward in 1985.
Sure.
Your Honor, the state has no objections to pretrial.
All right. So Mr. Butler, you'll be released to pretrial supervision. Yes. Yes, thank you. Yes. All right. I thought, I called it before. Who's here?
Mr. Kaiser is here, Judge. That's who their deputies are informing me. I believe that was Mr. Shade's case.
Right. We did find probable cause on Mr. Kaiser.
Mr. Kaiser.
Yeah. Can I just, let me just. Oh, is it still up there? Can we bring one of the PCs if there's? Thank you. All right, Mr. Kaiser, just to inform you, you are before the court today. Counts 1 and 2 are municipal ordinance violations. And your attorney was here on those matters. On count 3 and 4, it's felony violation of probation. Those are no bond holds. And so you will be before your division judge tomorrow at 8:30, and then there's a bond on count 1 for $25. Okay? All right, good luck, sir. All right, we're recalling on Lagari Yutzi on page 4.
Yes, Judge, he is here. Mr. Yutzi, come on up, please.
That's okay, no problem. Are you okay over there?
I'm sorry, I fell up trying to run back up.
Oh. All right, so, Mr. Yutzi is before the court. Count 1 is a battery. Count 2 is false imprisonment. And I do find probable cause as to the charges, and I'll hear from the parties as to bond.
False imprisonment.
Ma'am, who are you?
I'm girlfriend. I'm the person, the victim.
What is your name?
Daphne Robinson.
Okay.
With that, the imprisonment one, that was not true. My baby's father, Cortez King, was just released January 8th. He has it's been altercation since I decided to move on, and me and Lagari has been together for 4 years, and he's been trying to break us up, trying to find ways and everything. I have proof of that as well.
Ma'am, you may not want to talk about your case, all right? Why are you here?
Because the recent report, I don't want to do anything about that, no charges or anything about that.
Okay. All right. Are you the one who will be posting the bond? Yeah. Okay. And you want to talk about how much bond you're able to post?
How many cases?
Yes.
The recent one.
All right. State?
Yes, thank you, Your Honor. I'm going to be seeking bond in the following amounts. One moment. $5,000 on count 1, $5,000 on count 2. I would note, as far as the allegations, according to this report, the allegations came from Ms. Robinson herself. The father of her child is not mentioned anywhere in this report. I would note the batteries corroborated by her 2 children who witnessed Mr. Yutzi attacking her, which is even cause for greater concern. There were physical injuries that corroborated her allegations that she advised law enforcement of. I would also note that Mr. Yutzi was arrested in 2018 and 2016 for domestic violence battery against a different alleged victim. Each case was dropped. He was arrested last year on a capias on the battery for failing to appear in court. He has a 2009 possession of cocaine, 2010 resisting without violence, 2009 resisting without violence. I would also be requesting that the court issue an order of no victim contact.
All right. Mr. Romero?
Thank you, Judge. And speaking, Mr. Yutzi, I did explain to him, unfortunately, the court is bound by what's written within the 4 corners of the affidavit. And today is not his trial date. We will have a day in the future to contest these allegations. Certainly, the court can, for mitigation purposes and for bond consideration, could take into account what the alleged victim is saying, that she's not in fear and that she's contesting these allegations. Basically, in speaking, Mr. Yutzi, he's 32 years old. He's been residing in our community for about 19 years now. He just got a job approximately 2 months ago working for TNS Lawn Service, where he makes approximately $80 a day. Now, I did advise him on all domestic situations. Most likely the court is going to impose a no contact order, and he will be abiding by the court's order He'll be residing separate and apart. He'll be living with his mother, who resides in Dania Beach, and I believe she works at Walmart. Judge, what I'm going to be asking the court to consider is take into consideration what the alleged victim stated, and I believe $1,000 bond on count 1 and $1,000 bond on count 2 would be reasonable under the circumstances.
All right. You are correct that I am bounded by the four corners of this complaint affidavit, which alleges that Ms. Robinson was slapped on the right side of her face, grabbed by both her legs, pulled off the couch, landed on the floor, that she was punched several times on the left side of her body, that there are two minor children, 7-year-old and 5-year-old in the house, that she ran out of the house to one residence, and when she wasn't able to get help there, she ran to another residence where she was able to call 911. And that the officer observed bruises and scratches. And so based on this probable cause affidavit, I do find probable cause. As to count 1, I am going to impose a bond of $10,000. On count 2, it's going to be $5,000 and no victim contact until further order of the court. All right, good luck, ma'am. Should I give away your papers? That happens all the time. Which one? I know, she's like.
Thank you.
All right, Mr. Glassman is out of the room.
Your Honor, he had to run some other quorums, and we found out the ASA assigned to the case is going to be coming here also, so.
All right.
We should just put on recall.
No problem.
Thank you.
All right, so let's go back to, I don't know what page we're on, but it's Charles Yates.
Judge, he's approaching. He's here, Maine.
All right, thank you. On page 7, Charles Yates. Mr. Yates is before the court for a violation of injunction stalking. I do find probable cause, and I hear from the parties.
Your Honor, the state is requesting a $1,000 bond and a GPS monitor.
Okay.
Judge, in speaking to Mr. Yates, unfortunately, right now, financially, he is indigent. He's homeless, but he does have a job. He just got a job working at the 595 truck wash, where he makes on a good day up to $120 a day. Judge, he's 31 years old, been here for the past 20 years. We're going to be asking the court to consider releasing him on pretrial release. So.
Well, Mr. Yates, there's an injunction in place that tells him that he needs to stay away, how far he has to stay away, have no contact with this alleged victim. The court is concerned that I don't know what can keep Mr. Yates from violating this injunction. So I do find probable cause. I am going to impose a bond of $1,000 with level 2 GPS. And I will say again, as was previously stated by other courts, no victim contact. Austin McCloskey.
Mr. McCloskey, come on up, please. He's approaching, Judge, here at Maine.
Hold on. All right, Mr. McCloskey, you're before the court for a DUI charge, and I do find probable cause.
Judge, and speaking Mr. McCloskey, I would like to see if Ayman Sajid can tell us if his bond's already been posted.
Oh, okay. It's not showing yet, if it is.
Okay, I'm sure it's going to be on shortly. He did give me the phone number of his family member. I'll call them after court to see if there's any problems.
All right. The bond is $1,000. Mark Clauda.
Yeah, sure. Claudia, come on up, please. He's approaching.
All right, so Mr. Clauda, you are before the court. Charge number 1 is possession of cannabis 20 grams or less. Count 2 is possession of drug paraphernalia, and count 3 is a municipal ordinance violation. And I do find probable cause.
Judge, just being Mr. Claudia earlier today, we wanted to know if the state has a plea offer for Mr. Claudia.
Okay.
Yes, Your Honor. For counts 1 and 2, the state is offering a withhold of adjudication and court costs.
All right.
Judge, just being Mr. Claudia, he wishes to accept the state's offer.
All right, Mr. Clauda, you understand everything that's going on here today?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right, you can put your hand down. Do you need any more time to speak with your attorney?
No.
You understand everything that's going on here today?
Yes. Yes.
And you understand that you have the right to go to trial, but if you take a plea today, you're giving up that right?
Yes.
All right. Are you under the influence of drugs or alcohol?
No. No.
Have you ever been treated for mental or emotional illness? No. And you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes.
Yes.
What plea do you wish to enter, Mr. Clauda?
Go. No contest.
I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence serves a withhold adjudication and court costs. Good luck.
And that would be for all counts, correct?
Yes. Yes, all counts. Vernon Keat, is he here today?
No, he's a medical researcher.
All right, thank you.
Welcome.
And Georgilis Paulino.
I've been advised bonded, Judge.
All right. Thomas Rigetti.
Judge, medical reset.
Okay. Enrique Herrera.
Come on up, sir. He's approaching, Judge, here at Maine.
Mr. Herrera, you are before the court for count 1 is a possession of cannabis 20 grams or less. Count 2 is possession of drug paraphernalia. And count 3 is a municipal ordinance violation. Count 4 is a violation of misdemeanor probation. You've been ROR'd on that count. I do find probable cause. And what is Mr. Herrera, his bond is $100 on count 1.
Judge, I'm going to be asking that the court consider an ROR on count 1, the misdemeanor possession of cannabis under 20 grams.
He's still under probation. I'm pretty sure a condition of his probation is no alcohol or drugs. Looks like he was engaging in both here.
Looks like this is an old VOP warrant. Is he still reporting to probation? This is a 2016 warrant.
My guess is he hasn't been reporting in since the warrant was issued, or they would have taken him into custody.
All right. I will, ROR on, count one.
Thank you, Judge.
Trevor Dorsey.
Mr. Dorsey, come on up, please. He's approaching, Judge. You hear me?
All right, Mr. Dorsey, you're before the court. Count one is disorderly conduct. Count two is resisting officer without violence. Count three is trespassing. Count four is littering. That's not for magistrate, so I do find probable cause.
Judge, and speaking Mr. Dorsey, he wishes to resolve this matter today.
Does the state have an offer for Mr. Dorsey?
Your Honor, the state has no offer. He was just released yesterday, and we're asking for a bond.
It was released.
He was released yesterday for domestic violence battery plus a resisting without violence.
But what kind of release is he on? A bond or?
Yes, Judge, $2,500 bond. The state is asking for a bond increase on count two, the resisting officer without violence, to $500.
Judge, considering what the state just said at this time, then I'd ask the court to consider just leaving the standard bond in place on count two.
You know, the allegations here are that the officers made several attempts to ask Mr. Dorsey to leave. And when he wouldn't, and they wrote him a ticket for the trespass, he took the ticket, ripped it up, and threw it away. So, as to count two, I am going to increase the bond to $500. All right, good luck, sir. Louis Sentinel.
Mr. Sentinel, come on out, please.
Mr. Centeno, you're before the court on two misdemeanor capias. Count one is possession of cannabis, and the second count is driving while license suspended. The bonds on each count is $1,000.
Judge, at this time, nothing to add from the defense. I will be contacting his father after court.
Okay. Do we have Mr. Cade today?
I don't know North
Broward, but I think he's a medical reset.
He's still on medical reset?
Yes, he is.
All right, thank you. Craig Strong?
Medical reset also. No.
All right, thank you. Ellis Jones?
Conti, Your Honor.
All right, good morning.
Your Honor.
Yes.
He said he had two no bond holds and he refused to come.
Judge, that's correct. I would just ask you to leave the standard bond in place.
All right, so I find probable cause as to charge number 5, and the bond is $2,500.
Thank you, Judge.
Kevin Henry? Do we have Kevin Henry?
I'm sorry, Judge. Who did you call?
Kevin Henry?
Okay, Mr. Henry. Kevin Henry. Judge, he's approaching. He has private counsel, Mr. Bill Jones. Come on up, sir.
Okay. All right, Mr. Henry, is this an add charge or a change of charge?
It's an ad charge, Your Honor.
All right. So, Mr. Henry, you have an add charge for possession of, this is charge number 9 for possession of weapon or ammo by a convicted felon. So, I do find probable cause. You will be in court tomorrow in your felony division.
Yes, sir.
All right. So, I'm going to impose a bond of $1,000 on this count, and then you'll see your division judge tomorrow. Okay?
Thanks, Your Honor.
All right, sir. Take care. Maurice Williams.
Mr. Williams, come on up, please. He's approaching Judge. You hear me?
All right, Mr. Williams, you're before the court for one count of grand theft. And I find probable cause. All right, I'll hear from the parties.
Judge, in speaking with Mr. Williams, he's not going to be able to afford the monetary bond which is associated with this case of $7,500. He's been living here his whole entire life. He's 22 years old. At this time, he is homeless. He does have a mailing address. He has a friend that resides in Fort Lauderdale that he can use address in order to get future court correspondence so he can be sure to go to his court dates. Now, what he did advise me is he's working he's been working now for about 2 weeks where he gathers signatures for a petition in which they kind of pay him for the amount of signatures he can get. And he made last week, from what he advised me, $150. He did say, advise me he's not a convicted felon, Judge. So, Judge, considering this is a non-violent offense, I'm going to be asking the court to consider releasing Mr. Williams on standard pretrial release on this case, or reducing the $7,500 to a $1,000 bond.
Okay.
Your Honor, my concern is, in 2015, he had a possession of PVP arrest. He was placed on pretrial. He ended up not showing up in court. He was arrested on the capias, he got out, and then was arrested again on the capias. And it dragged a 2015 third-degree possession case out till it was ultimately resolved in 2018. And that's my concern in this matter. He doesn't appear to go to court, even when he was placed on pretrial.
Judge, I believe the date incident on that case was, maybe, correct me if I'm wrong, like 2015, around there. So basically, last time he got in trouble was for arrest that happened back in 2015.
That's exactly my point, is that...
Right. These allegations are concerning, that he's working at Burger King, he's a shift manager, that he used the information that he had to go back to Burger King after the business was closed to steal money. Those are the allegations that I have before me today. And so I do find probable cause, and I find that a reasonable bond is the $7,500. Jamal Patterson.
Mr. Patterson, come on up, please. He's approaching, Judge.
All right. All right, Mr. Patterson, you're before the court today for a grand theft auto. I do find probable cause, and I'll hear from your attorney.
Judge, at this time, nothing to add. I'm going to be contacting his girlfriend right after court.
Okay. State, do you wish to be heard?
Yes, Your Honor. The state asked for a $1,000 bond and also no victim contact. He also has priors.
Right, $1,000 is the bond, no victim contact. Good luck, sir. Chevin Scott.
Mr. Scott? He's approaching, Judge. He's here.
All right, Mr. Scott, you're before the court for grand theft auto. Count 2 is resisting without violence. Does the parties wish to be heard as to bond?
Judge, at this time, it's being Mr. Scott. Nothing to add. I'm going to be contacting his mother, his sister, and his brother to help post his monetary bond.
Okay.
For count 2, the state is requesting a $500 bond.
All right, so the bond on count 1 is $1,000, and on 2 will be $500. Good luck, sir. Kelsey Burns.
Mr. Burns is here present, Judge, in Maine.
All right, Mr. Burns, you are before the court for count 1 is possession of cocaine. Count 2 is not for magistrate, but it's careless driving. I do find probable cause.
Judge, and speaking of Mr. Burns, I'm going to be asking the court to consider releasing him on pre-trial release. I'll see if the state has an objection.
The state is okay with the ROR, Judge.
Thank you.
All right. ROR, Mr. Burns. Good luck, sir. Anthony Lewis, ROR, yes. Anthony Lewis.
Judge, Mr. Lewis is here. I'm going to need a moment to speak to him, okay?
All right, you can let me know when you're ready. James DeCourcy. All right, Mr. DeCourcy, you're before the court for possession of cocaine. And I find probable cause.
Judge, and speaking Mr. DeCourcy, unfortunately no one's going to be able to post his monetary bond. We're going to be asking for pretrial release on this nonviolent offense. I'll see if the state has an objection.
The state has no objections, Your Honor.
All right, Mr. DeCourcy, you'll be released to pretrial supervision. You need to make sure that that information the attorney's handing you, that you report, because if you fail to report, there will be a warrant issued for your arrest.
Okay, you're gonna be released today.
Yes.
Look, this is where you are, the main jail.
Right.
You follow
State,
the
thank
map, you
you,
walk
Judge.
across the street, you cross Third Avenue, there's free trial. You have to report there. If you fail to report,
Right
there's
after
gonna be a,
that.
there's gonna be a warrant issued for your arrest. You
I'll be
understand?
right there, yes.
Beautiful. All right, good
Thank
luck.
you, Judge.
You're welcome. Diego Radlin,
Judge, I've been informed he bonded.
all right. Matthew Ferguson,
Judge, I'm gonna need a moment to speak to Mr. Ferguson.
all right. What about Cortez Walker?
Mr. Walker, come on up, please.
All right, Mr. Walker, you are before the court today. Counts 1 and 2, resisting officer without violence. Count 3 is trespassing. Count 4 is reckless driving. Count 5 is riding a motorcycle without eye protection. Count 6 is unlawfully operating on a public road. 7 is disobeying stop sign. 8 is 9 and 10 are felony violation of probation. 8, 9, and 10 are no bond holds, and you'll be before your division judge tomorrow at 8:30. Counts 5, 6, and 7 are traffic infractions, not for magistrate. I do find probable cause. Your bond on count 1 is $100. Good luck, sir.
Good luck, sir. I still gotta talk to you. Hold on, I gotta talk to you.
Which one?
She said she forgot that one. That was the first one we did this morning.
All right, Gabriel Bonner.
He's here, present judge.
All right, Mr. Bonner, you're before the court today. Count 1 is possession of cocaine, and count 2 is possession of cannabis, 20 grams or less. I find probable cause.
Judge, the court having found probable cause, nothing to add from the defense. I will be contacting Mr. Bonner's girlfriend after court so she can post his monetary bond.
All right, so the bond is $1,000. Eric Hildebrand. Hello,
And
Brand.
Judge, at this time, I'm gonna need a moment to speak to the, I haven't gotten past that, to the rest of the people, Judge.
All right, so
But you can certainly go to the other facilities.
Judge, I can call someone
is there anyone
at a northern facility.
at North Broward? Is there anyone at North Broward that we can call?
Judge, if we start on page 29.
You have to tell me the name because I don't go by the
Sure,
docket.
Darwin Mingo, I think, was a medical reset.
Right.
I think Keith Williams is North Broward and is a medical reset.
Keith Williams is a medical reset?
I believe so.
Yes.
Deputy, that's
Yes.
correct?
Yes, sir.
Delvin Nash on the bottom of page 29 is in Paul Ryan. He's present. There he is.
Delvin Nash.
Paul Ryan, Your Honor.
Thank you. Okay. 3,500? All right, so Mr. Nash, I'm told that you were before your division judge yesterday, and on this charge, there's already a $3,500 bond that's been imposed. Okay?
Yes.
All right, so that's all we needed to do today. Good luck, sir.
Thank you, Judge.
Thank you.
All right?
I think
And-
that's it
and-
for the
and that's
northern
it?
Jails, yeah.
Do we have anyone else at Paul Ryan, Conti, or North Broward that we need to address?
No, ma'am, that's it for North Broward.
All right, thank you. Then we'll take a brief recess and then we'll be ready. Mr. Romero, are you ready?
Yes,
Okay.
I am.
All right, so Anthony.
Thank you, Judge, for giving me that opportunity, by the way.
No problem. Anthony Lewis.
Mr. Lewis, come on up, please.
All right, so Mr. Lewis, you have a civil writ with a purge amount of $235, and count 2 is robbery, no firearm or weapon.
Judge, in regards to count 2,
All right, I find probable cause. Oh. All right, does anyone wish to be heard as to the bond?
yes, Your Honor. In regards to count 2, the state is requesting a $25,000 bond. Looking at the facts and circumstances of this case, in addition to the defendant being released, well, he was charged with aggravated battery with deadly weapon in 2005, and he was released from prison on June 8th, 2018, after a 15 years prison sentence. In addition, the state is requesting that the defendant have no victim contact and a GPS monitor.
Okay.
Judge, and speaking of Mr. Lewis, unfortunately, he's not going to be able to afford any sort of monetary bond. He's homeless at this time. What he did advise me is he applied for disability a couple months ago, and he's waiting to hear from them. So he has no financial income coming in. He's 37 years old, been here his whole entire life. Now, he does have family that live in Broward County, specifically his grandmother, that he can use her address to get future court notices. But right now, there's no one that can post his monetary bond. So I'm going to ask you to take that into consideration in determining reasonable release conditions for Mr. Lewis.
All right, I do find probable cause. I am going to impose a bond of $10,000 on count 2 with level 2 GPS. No victim contact. All right, good luck, sir. Matthew Ferguson.
Come on up, sir. Please approach the judge.
All right, Mr. Ferguson, you're before the court for battery on an officer. Count 2 is resisting officer with violence. I do find probable cause. Does anyone wish to be heard as to bond?
Yes, Your Honor. In regards to count 1, the state is requesting a $1,000 bond, and for count 2, a $500 bond.
All right.
Judge, under the circumstances, that's reasonable. I'll be contacting Mr. Ferguson's father after court.
Okay, so count 1, 1,000, count 2, 500. Eric,
And Judge, request a photo order just in case.
sure. Eric Hillebrand? 1,000 on 1, 500 on 2.
Mr. Hillenbrand, come on up, please.
Sir, you're before the court. Count 1 is possession of possession of heroin. Count 2 is possession of alprazolam, and count 3 is possession of drug paraphernalia. I find probable cause.
Judge, nothing to add from the defense. I'll be contacting Mr. Hill's father.
All right, so the standard bonds are in place. Kelson Monroe. Okay, Mr. Monroe is before the court. Count 1 is attempted felony murder. Count 2 is aggravated battery with a deadly weapon. Count 3, aggravated assault with a deadly weapon without intent to kill. Count 4, aggravated assault with a deadly weapon without intent to kill. Count 5, carrying a concealed firearm. Count 6, grand theft of a firearm. Count 7, under 18, unlawfully possessing a firearm. I find probable cause as to all those counts. And I will hear from the parties in regards to the bonds.
Your Honor, regarding count 1, the state believes that there is proof evident presumption great. We're asking that the youth be held no bond for that count. Regarding count 2, the state is requesting $150,000 bond. Count 3, $150,000 bond. Count 4, $150,000 bond. Count 5, $50,000. Count 6, $50,000. And count 7, $50,000. The state is also requesting that based on the facts and circumstances of this case, the youth at the time possessed a stolen firearm. In addition to that, he fired several times at the victim, in which at this case we are known that the victim is paralyzed. In addition, if it had not been for a witness that observed this altercation, and also other victims could have been also harmed by this. There were 2 young girls that were there present during the time where the bullets could have also hit them.
Okay.
Oh. The state is requesting that the youth have no victim contact in addition to no contact with the witnesses.
All right, Mr. Romero?
Judge, in reference to the state's request as far as proof evident presumption great, I believe my colleague, Mr. Goldberg, will address that issue.
Okay.
Judge, we do represent Mr. Jacobs. Ms. Robbins represented
Mr.
him.
Monroe?
Mr. Monroe, I'm sorry.
Okay.
I had the different on my computer. We do represent Mr. Monroe. We're going to withhold at this time objection to the proof evident. The only thing that I would ask is he's obviously a juvenile. He's a direct file. He's got some family members that are in the courtroom here today. I don't have a probable cause objection to these allegations.
Okay. Good morning, ladies. Is there something that you wish to say? Okay. Good morning, ma'am. You don't have to say anything, but you're here and you're standing at the podium, so that's why I ask.
Judge, I just walked in a moment ago. I advised them not to speak about the allegations.
Okay. All right. So I do find probable cause, and the allegations in this affidavit, which is what I get to make my determination on today. This is not his trial. He'll have his time at another time to have whatever hearings his attorneys deem necessary to schedule, but at this time I do find probable cause. I am going to, based on the affidavit, the warrant to arrest that has been presented to me, make a further finding of proof evident presumption great. This is, of course, without prejudice, and he will be able to have a bond hearing based on State v. Author in his division. So as to count one, he will be held no bond until further order of the court. Counts 2, 3, and 4. The bonds will be $150,000 on each count. The standard bonds that are in place on 5, 6, and 7 will remain in place. There's 1,000, 1,000, and 100. And until further order of the court, no victim, no contact, which means no phone calls, no social media, no texts, no asking anyone else to get in touch with this person.
Your Honor, the state my apology, Judge.
What are you gonna say?
The state is asking that the youth have no contact with the witnesses also because there are 7 eyewitnesses.
Okay. All right, no contact with the witnesses. All right, so that's it. No possession of if he's out, no possession of firearm or weapons if he's able to post his bond. All right, good luck, sir. Lindsay McPherson. Mr. McPherson, you're before the court, driving while license suspended, and count 2 is an out-of-state felony hold. I do find probable cause. You will be going before the extradition court Tuesday or Thursday. I don't know, does he wish to do anything with count 1?
Not at this time.
All right, so the bond is $100. Good luck, sir. Martavius Ward.
Come on up, sir.
Mr. Ward, you are before the court. Count 1 is dealing in stolen property, and I do find probable cause.
Judge, in talking with Mr. Ward, he did give me the phone number of his family friend. I will be contacting her after court.
All right, the bond is $3,500. Maurice Jones.
Sorry, Mr. Jones, come on up, please.
All right, Mr. Jones, you are before the court. Count 1 is failure to return a rented vehicle. Count 2 is driving while license suspended. Count 3 is grand theft. Count 4 is a civil writ that is not from magistrate. you can purge that by paying $622. I do find probable cause. And
Judge, in speaking with Mr. Jones, all his financial resources of his friends and family are going to go towards count 4, paying the purge amount of $622. Therefore, I'm going to be requesting the court consider placing Mr. Jones on pretrial release on counts 1 through 3. He's 59 years old, been living here for about 20 years in South Florida. He is working, he just got a job working at Auto World, in which he's been there now 3 weeks. My understanding is he lives in Lauderhill by himself. He's been there for about 2 years. His monthly rent is approximately $950. So, Judge, I'm asking on counts 1 through 3, the court consider releasing him on pretrial release.
Your Honor, the state would object to pretrial release. First, Maurice Jones is an alias. As you can see, it lists Hector Jones as an alias. According to the state of Georgia, his name is Hector Jones, and Maurice Jones is the alias. I hear, Mr. Romero is advising, well, the family's going to pay the writ off or immediately. This writ, this non-support has been going on since 2011, 2012. I'm not convinced it's just going to get paid off just like that. I think these bonds are appropriate.
aside from the writ, does he have priors?
One moment, Your Honor. He was arrested twice in Dade for the same offense, failure to redeliver. Those were both dropped. Out of the state of Georgia, just a very old theft.
All right. Is this probable cause affidavit where Mr. Jones attempted to make payment? Well, he gave a check for the $800, but it turns out that the check was as a fraudulent. All right, I'm gonna leave the bonds in place. 1,000, 750, and 1,000. Good luck, sir. Ruthie So.
Mr. So, come on up. Judge, he is approaching, and he declined the services of public defense.
All right, Mr. So, do you have a private attorney?
I do not, ma'am. Judge.
You're going to be hiring someone?
No.
All right, you're before the court today for grand theft auto, and I define probable cause. And do you wish to say anything in regards to me setting your bond?
No, my bond I got for $1,000, but this is like my second time being in this system, so I'm not familiar with how this process works. But I actually work for the company, so eventually I know that.
Stop. Don't talk about the case. All right. So, State, do you wish to say anything?
No, Your Honor.
Just to make sure, am I waiting on a response from the state or no?
Your Honor, no, the state has no response.
Okay, then $1,000 is the bond. Good luck, sir. Gilberto Sanchez.
Mr. Sanchez, come on up, please. He's approaching, Judge. Judge, we just found out Mr. Sanchez is going to need a Spanish interpreter.
Oh, wow. Okay. All right. D'Angelo Haywood.
North Broward, I believe, Judge.
No.
Judge, Mr. Haygood is here at Maine. I apologize. And he has private counsel, Mr. Brian Greenwald. I believe my colleague may have tried and reached out to him.
Judge, I was texting with Mr. Greenwald earlier. He's aware of the proceeding. I think he's stuck in court elsewhere right now. But I see,
It's a change of charge.
I think this case is set for an arraignment tomorrow before Judge Garcia would.
Okay.
D'Angelo
This is
Haygood?
D'Angelo Haygood.
Your Honor, I can.
Yes.
I pulled the findings. When he appeared before Judge Benson, March 15th,
Yes.
he found proof evident or potential
For attempted murder, right?
Wrote an attempt.
I figured.
Yeah.
All right.
So I would just be asking the court to adopt Judge Benson's previous findings.
So Mr. Haygood, this is just a technical change. It is what the previous magistrate judge found at your first appearance. So it's attempted murder. That's what the probable cause was found for at the time that you were before the court. And I believe I hear that you have arraignment when?
Looks like arraignment is scheduled for tomorrow before Judge Garcia
So you should be before your division judge tomorrow. So I'm gonna leave everything in place as it was when you came the first time, and then your attorney will be able to address the judge tomorrow, okay?
Okay, thank you.
Okay. And then Derek Sensor.
Here at Maine, Judge.
Is this similar?
It's exact. Your
It's
Honor.
exact.
I pulled the findings, and Your Honor wrote in attempted burglary.
Okay.
And you said a $5,000 bond.
And there was a $5,000 bond? Okay.
And Judge, my understanding, Mr. Sensor also has an out-of-county hold, so nothing to add from the defense.
All right, so I find probable cause again, and the bond is $5,000.
Judge, I spoke with the interpreter's office.
Yes.
They'll get someone in here as soon as they can. All of their Spanish interpreters are out right now.
All right, so I'm gonna take that to mean we're resetting this for the afternoon.
Very good. I'll inform them.
Thank
you, Judge.
Gilberto Sanchez, we will reset to the PM, because we need a Spanish interpreter. And what about Neil Greenberg? Where
Your
do,
Honor, I think,
I've lost both, they both were
I
here.
think they're right outside of it.
Okay, all right.
No, they're waiting on your attorney and the prosecutor, so I
That's-
oh, okay. Judge, my understanding.
I think they're
believe-
outside.
What, sir, what's your name?
Greenberg?
He's got a private attorney. Mr. Glassman is here.
He's gonna be reset. So Judge, everybody's been addressed here except for the gentleman with the private attorney, Mr. Matthew Glassman.
Okay, thank you.
Did we handle Diego Radlin? Let's check. Don't beat yourself up about it. So just write on the bottom.
Just posted bond.
Posted. How you feeling? Feeling better this time around?
Even though it's still nerve-wracking, but
You started to see what I was telling you.
yeah.
Break it down into pieces.
You have to say it again. Now we're back on the. All
Matthew
right,
Glasgow. Did you get me, Judge?
I got you.
Come on.
You got me. Okay.
There's your attorney right there in the bottom center. Okay. The guy with the bow tie. Mr. Matthew Glass.
All right, what are we doing, Mr. Greenberg?
Well, Judge, we are trying to, I have tried to negotiate a bond for Mr. Greenberg. He's 60 years of age. He suffers from multiple health ailments. He has absolutely no prior arrests. He's a 40-year resident of Broward County. He doesn't own any property. He rents currently. He doesn't own a car. And he has about $15,000 in assets that he would be able to use within a 2-week period to post a bond, and the potential to get another $5,000 in assets. His ex-wife is here. She's still his best friend. Her name is Joanne Greenstone. She has a apartment, or she has a townhome that she's willing to put up on his behalf. The amount is somewhere in the range between $150,000 and $200,000 for the appraised value. We were looking for a bond in the range of $250,000 with an electronic monitor, level 2, or level 1 if the court insists. He's not a flight risk. He's been in Broward his entire life. I have issues with the number of charges. I think there are PC issues for several of those charges. At this point in time, the biggest issue for us is the monetary value this court sets as a bond. And we'd like to focus more on that part than pick apart 77 or 74 individual charges. But if need be, there are several charges that I do deem would be outside of the statute of limitations. Some going back to 2012 and 2003 that would be outside of the 4-year period for a second-degree felony. Be that as it may, at this stage of the game, knock it down from 74 charges to 66 charges. There are other issues as regards to knowledge for all the third-degree felonies. There's 36 counts of that. They have to prove knowledge that he knew the victims were under the age of 18 at that time. It's element number 3 for the jury instruction. So there are issues, there are PC issues, but I don't want to make a big deal out of the issues. I just want to try to get him out because of his health issues, because he has no priors, because he's a Broward resident of over 40 years. He's lived in the same place. He's not a flight risk. He's not going anywhere. And he's willing to wear a monitor.
All right, State?
Good morning, Judge. The state would be asking for $10,000 on each count for the child porn cases. For the unlawful sexual activity with certain minors, the state would be asking for a $25,000 bond, and then I think it was listed as $2,500 for the unlawful use of the two-way communication device. That can remain the same. This is not your. I think that this is a more in-depth child porn case where you have somebody that's not just downloading the images, the videos, he's also creating them. There are sworn statements from victim AR that he was aware of her age. This has been ongoing, dating back to at least from what they obtained from the search warrant back in 2013, if not longer. He runs a website, independentgirls.com, where it basically is promoting an escort service, promoting these girls online for sex. So based on all that information, I think that he is, also the letter that he wrote that is stated in the probable cause affidavit, I think it shows a certain level of sophistication. He clearly is aware of what he's doing. So in addition to the $10,000 on each count, the $25,000 on the unlawful sex with certain minors, I'd also be asking for pretrial release with a GPS monitor, no access to a computer, no access to the internet, no cameras, no cell phone with cameras, no contact with the victims, no contact with minors, and no weapons.
All right.
Because there is one other issue. He has
Yes.
pets in the home. The officers did not take the pets. At the very least, I'm hoping the court will set a reasonable bond to give him a chance to bond out and do the pretrial release with the special conditions that the state has set forth. But at the very least, I need permission for for his ex-wife to get into the home and take care of the animals. I don't know if Your Honor can help facilitate them signing out his keys, because even if he's able to post the bond, these animals, I don't want them to starve or die or be maltreated. So if you can help assist us in them vouching out his property to her so she can take care of those animals, that is of the utmost importance as well.
Well, if Mr. Greenberg wants to give his keys or whatever to whomever, he certainly is allowed to do that if he needs me to sign an order to allow him access to his property so he can give that to them. I have no. Okay. All right.
That's my understanding as well. The problem is the wheels of justice sometimes tend to move slow. I had a client released at 9,
I'm not sure that my order will make it go any faster,
Well,
because the jail is going to do what, they're going to follow their own procedures.
I hear you, but I don't want the animals or the loss of life for these pets to be on my conscience.
All right,
Something-
so as to that, what are you proposing?
I just would ask the court for any help you can provide us. I understand that they have their own system, but an order from you.
Confinement is do you know if an order from me?
Order's not gonna expedite it. Where he is housed right now, they can provide him with a voucher, and all he has to do is fill out that voucher right now, stating everything that he wants to, who he wants to give it to. But he has to send it back.
Mr. Greenberg, are you hearing this?
All right, you can turn on your microphone so we can hear you if there's anything you wish to say. So, I'm not the boss of the jail, so to speak, so I can't order them to do anything.
Yes, I can hear what's being said.
Okay.
All right.
I don't want you to talk about anything else. I just want to make sure you vouch out that information so the animals can be taken care of, okay?
All right, so these allegations before the court are very concerning. There is cause for concern to the community and minors. And so I do find probable cause. I'm sure, Mr. Glassman, that there are motions, and if it's not 74 counts and that you can make those before the division judge. But at this time, I do find probable cause. Counts 1 through 36. I'm going to impose a bond of $10,000 on each count. $37 through $72. I'm going to impose a bond of $25,000 on each of those counts. Count 73. Count 73, I'm going to impose a bond of $50,000. Count 74, it's $2,500. No victim contact. No access to internet or any device that'll have that access. If Mr. Greenberg is able to post his bond, he will be on a level 1 GPS.
Recommend to the court no cameras?
No cameras, that's, yes. No contact with minors, I thought I said that, but If I didn't, no contact with minors.
And then the state would also be asking for no weapons.
I'm writing it all on no weapons or firearms.
Judge, we don't have any issues with pretrial release, but that bond's close to $1.5 million. That's tantamount to no bond at all on someone that has no priors.
All right, and the court does have to take into consideration not only the dollar amount, but the cause for concerns for the community and any other thing that the court wishes to take into consideration. So those are gonna be my orders at this time.
Thank you, Judge.
All right.
Yes, ma'am. I hate you to see homeless. So, yeah, good job. No, you're done. We don't have to come back to the afternoon. Anytime